I'm doing this video. I'm doing this video from a different location today in order to make sure that I get some interesting information out to you quickly. Uh, there was a case last week in South Florida where a lot of these ingenious twists come from. That's really important. Basically, it boils down to this, and it's pretty straightforward. It's just never been applied. When a mortgage holder plaintiff sues to foreclose a mortgage, it names the association as a party, and it alleges that its interests are superior to that of the association. It doesn't seek any money. It just wants its rights vindicated, if you will, and held to be in first place. Part of the problem that associations face is that these foreclosures tend to drag on and on and on. What one firm in South Florida managed to do last week or the week before was to actually file for what's known as a summary judgment against itself, against its own client, I should say, where generally speaking, summary judgment is a tactic used to bring a swift end to litigation where there is no dispute over the facts. In other words, unlike, say, the O.J. Simpson case where there was a dispute as to whether it was his blood, whether the glove fit, what Kato Kalin heard, what kind of wounds there were, etc., etc. In a summary judgment case, the party moving for summary judgment simply says to the court in a motion supported by an affidavit that there are no facts in dispute. No one's alleging that anything factual is in dispute. It's only a matter of law. Now, generally, a defendant in a lawsuit is not one who moves for summary judgment against itself, which makes this so unusual. But in this case, it makes perfect sense for an association to allege that it is all of the allegations against it as set forth in the complaint are true, that no facts are in dispute, and what the association seeks is a quick determination of the fact that the plaintiff is correct in its allegation that its interests are superior to that of the association, and to take all steps reasonably necessary to get the title vested into the plaintiff, meaning the foreclosing, or I should say the foreclosing plaintiff, as soon as possible. This is something that can be tried, for example, if an association takes title to a property and can't manage to rent it or can't manage to sell it to a third party who's going to be renting it or trying to sell it, or where, as I've spoken about in other videos, we can't get the first mortgage foreclosure dismissed as a bad faith foreclosure. By the way, we're about 20 for 20 on those and have 300 more scheduled. And in those cases, of course, the association quickly proceeds to knock out the first mortgage foreclosure, conclude its foreclosure, and take title. But that's another video called Bad Faith Mortgage Foreclosures. But in this case, if the association has taken title, has not found anyone who's willing to rent it or to take it off your hands, you should discuss with your own counsel the opportunity to file a summary judgment against yourselves and to get title as quickly as possible into the foreclosing plaintiff, so that when that occurs, then the plaintiff will be vested with title, will own it, will have to pay ongoing assessments, will have to pay past assessments, and maintain the property. So good luck.